Hello again. After I'd finished making those videos of the conceptual and analytical frameworks that you'll need for tackling an assessment question on EU democracy or legitimacy or lawmaking and so on, I thought that perhaps you might also want a lecture that's an introduction to the legal and factual information that you'll need to support your work. Now, this lecture is very much, as I've said, in support of work that you probably will have done already in other modules, and also work that you will be completing through the electronic workbook. So if you're comfortable that you've covered off all the factual information that you'll need and you've got the legal sources, then you don't need to watch this lecture. But if you want a bit of support with that, then keep listening. What I want to do here is to take you through the legal sources for the rules that govern lawmaking in the EU. I'll structure this in terms of what are the institutions that make EU law, how are their members elected or appointed, what processes are they legally constrained by, and what law do they make, what types of legal acts do they take. And throughout, the key legal provisions are the Treaty on European Union and the Treaty on the Functioning of the European Union. And again, as in the previous lectures, you will want to have copies of these texts in front of you. So if we turn to Article 13 of the Treaty on European Union, we'll see that this lists a formal list of the Union's institutions. And these are listed here on the slide. The key ones that we want to focus on in this lecture are the first four listed: the European Parliament, the European Council, the Council, which is different from the European Council, I'll explain a bit more about that in a minute, and the European Commission. So let's start with the European Commission. So the European Commission, if you turn to Article 17 of the Treaty on European Union, has the right of legislative initiative. So this is the right to begin the legislative process. And Article 17.2 provides that that right of initiative sits with the European Commission, except where the treaties provide otherwise. So you're probably thinking, as a good lawyer, well, where do the treaties provide otherwise? And for that, you need to turn to somewhere like Article 289 of the Treaty on the Functioning of the European Union. Just turning to that in my book. And Article 289 on the Treaty on the Functioning of the European Union talks about the ordinary legislative procedure where the Commission has the right of initiative. But it also talks about, in subparagraph 4, the specific cases provided for in the treaties where legislative acts might be adopted on the initiative of a group of member states or of the European Parliament, or in a recommendation from the European Central Bank, or at the request of the Court of Justice or the European Investment Bank. So you can see from there that the Commission normally has the right of initiative, but sometimes other institutions or combinations of institutions have that right. So turning back to Article 17 of the Treaty on European Union, Article 17.3 talks about the appointment of the Commission and the Commissioners. The members of the Commission shall be chosen on the ground of their general competence and their European commitment, although I'm not quite sure how one measures that. And they have to be persons whose independence is beyond doubt. The Commission is completely independent, Article 17.3 goes on to say, when carrying out its responsibilities. In terms of the responsibilities of the Commission and to whom the European Commission, by whom the European Commission is held to account, we can turn to Article 17.8, which says that the Commission as a body is responsible to the European Parliament. And that is the whole Commission, it's not individual commissioners. Turning then to Article 17.5, Article 17.5, the numbers of commissioners are set out in the treaty, The Article 17.5 provides that members of the commission have to be chosen from among the nationals of the member states, and they have to be based on a system of rotation between the member states. And this was put in the Treaty of on European Union with the Lisbon Amendments because of the expanding size of the European Union. And what is supposed to happen, according to Article 244 of the Treaty on the Functioning of European Union, so Article 244, we just turn to that. The members of the Commission have to be chosen on the basis of a system of rotation established unanimously by the European Council and on the basis of a couple of principles. But actually, when the Council came to take that decision, which it did in 2013, and the Council decision reference is there on the slide, and again reconfirmed its decision in 2019, the numbers of commissioners remains at the pre-2014 rules, i.e. there is one commissioner per member state. So there's an example where the treaty rules, the treaty text suggests that something should have happened or should be the case, but actually when it came to making the decision, the Council decided to do something slightly different or totally different in this instance. Again, in terms of the appointment process for the European Commission, we need to look to Article 17, subparagraph 7. Article 17, subparagraph 7 says that the formal appointment of the Commission is by the Council, but it is on approval from the European Parliament. And what normally happens is that prospective commissioners appear before the relevant European Parliament committee before Parliament gives their approval. In practice, the Commission functions through the personal staff of the commissioners, so they each have a relatively small cabinet of personal staff, personally appointed staff, who are national and EU officials. And those cabinets operate by liaising with the Commission's bureaucracy, and those are permanent officials appointed for the purposes of they're civil servants, effectively, appointed for the purposes of supporting the Commission. And those are organised into Directorates General. And the Directorates General reflect the areas of work that the European Commission covers. So there's a Directorate General for Transport, and there's one for the Internal Market, and so on and so forth. The European Commission can be censured by the European Parliament, and the provisions for that are covered in Article 234 on the Treaty on the Functioning of the European Union. Article 234 TFEU provides that a motion of censure has to be carried by 2/3 majority of the votes cast by the European Parliament, and they have to represent a majority of the competent members of the European Parliament. And if that motion of censure were to be adopted, the members of the Commission would have to resign as a body en bloc. Individual commissioners can only be removed under Article 247 TFEU, and that is only in the case of no longer being fit for service or in the case of serious misconduct. And in this case, there is a particular procedure set by the treaty. It's the European Court of Justice that makes the decision of to compulsory retire a commissioner, and it has to be on application by the Council or by the Commission. So those are the procedures for removing the Commission. Here's a summary of the powers of the European Commission. Again, these are all set out in Article 17 of the Treaty on European Union. So the most important power, particularly for the purposes of this topic, is the power of legislative initiative. In fact, it's often the Council that asks the Commission to look at a particular area for new legislation. The Commission has the responsibility to set the agenda in terms of its legislative plan. The The Commission has significant administrative powers once the European Union is active in a policy area and there's some kind of policy or programme going on. That policy or programme has to be managed, and the European Commission shares the responsibility to do that with national administrations. And for that, the Treaty on the Functioning of the European Union in Article 290 gives a significant amount of delegated powers to the European Commission. And the details of those delegated acts are set out in Article 290, and a delegated act has to be designated as such when it is adopted. The Commission also has significant executive powers, particularly over the European Union's external trade relations. So it is the European Commission, for instance, which is negotiating with the UK in terms of its future trade agreement with the UK. And the Commission negotiates on behalf of the European Union as a whole, on behalf of the Council in particular. And then finally, Article 17 talks about the European Commission's judicial powers. And here the most important one is the Court of Justice's jurisdiction under Article 258 of the Treaty on Functioning of the European Union to hear actions brought against a member state that the Commission considers is in breach of European Union law. And this is a part of the European Court of Justice's jurisdiction that you'll be wanting to refer to, particularly when you're answering problem questions in this module. So much for the European Commission. Let's turn to the European Parliament. The Parliament was historically a consultative assembly, and over time it has become a full co-legislator with the Council. And part of that process was indeed political, as you would expect, but part of it was also legal. The European Parliament and the European Assembly used litigation to increase its powers and control over the lawmaking process in the European Union. So initially, the treaties didn't give Parliament any locus standi to bring any claims, for instance, of judicial review of acts, but the European Court of Justice held in cases like the Chernobyl case that actually the way that the interinstitutional arrangements had evolved and the democratic legitimacy that Parliament brought meant that actually the treaty text should be interpreted so as to say that the Parliament did have locus. And then the treaty texts themselves caught up with that litigation, the findings of the European Court of Justice in those cases. And now if you look at Article 263 on the Treaty of the Functioning of the European Union, you'll see that Parliament has locus to bring judicial review claims. The parliamentary role has also been defended by the European Court of Justice, Parliament's role in terms of securing legitimacy for the lawmaking process in the European Union in cases like the linguistic diversity case, where Parliament was making sure that its powers were respected in the processes that were used to adopt particular pieces of legislation. This kind of litigation doesn't happen now because almost all lawmaking is happening through the ordinary legislative procedure, so there aren't so many procedural differences to have arguments about. If we look at Article 14 of the TEU further, it explains that the European Parliament has a significant role in terms of control and setting of the European Union's budget. Article 14.1 TEU says that the Parliament elects the Commission President, but actually if you look at Article 17.7 TEU, that says that it's the Council that proposes the candidates, so that's a co-electing process. Article 14.2 also talks about how members of the European Parliament are elected. They have to be directly elected as representatives of the Union's citizens, and representatives of citizens have to be digressively proportional. Digressively proportional means going up by degrees in proportion to the populations of the member states. And what that means that, in fact, the smaller member states enjoy better representation in the European Parliament than the larger member states. The largest member state can have only 96 MEPs, irrespective of the size of its population. Direct elections for the European Parliament have been held since 1979, but they do not use a uniform electoral procedure, despite what it says in Article 223 on the Treaty on the Functioning of the European Union, which can be said to be essentially an aspirational provision which has not yet been implemented. This provision requires the European Parliament to draw up a proposal to lay down how its members should be elected by direct universal suffrage in accordance with a uniform procedure in all member states, and the Council has to adopt that proposal. This hasn't happened. The statute for the European Parliament, adopted in 2005, does not provide for a single suffrage system. The suffrage system is different in different member states. Each MEP is elected for 5 years. MEPs have to be independent. They have the power to table proposals for EU acts. There are also provisions about their pay, expenses, and so on and so forth. According to Articles 289 and 294 in the Treaty on the Functioning of the European Union, the ordinary legislative procedure involves Parliament and Council as co-legislators on the basis of a European Commission proposal. So these three institutions are the key institutions in terms of ordinary EU legislation. And Article 289 3 TFEU sets out the legislative acts that are adopted through the ordinary legislative procedure. And these are also reviewable acts under Article 263 on the Treaty on the Functioning of the European Union. The process is set out in detail in Article 294 TFEU. Essentially, it involves 3 different readings and potentially a conciliation process between Council and Parliament. But the default position is that the proposal is not adopted. If the 2 parties cannot agree, or if they don't agree with the Commission, then the proposal does not become law. Article 226 TFEU talks about Parliament's control of the other institutions. Parliament may call a committee of inquiry to investigate an alleged contravention of EU law or a maladministration in the implementation of EU law. In practice, this would be by the European Commission in its administrative role. And the treaty goes on in Article 227 to give power to union citizens, but also to those resident in the European Union, and also to legal persons, to companies incorporated in the EU, to formally petition the European Parliament on matters within union fields of activity which affect them directly. Moving on then thirdly to the Council. Here, Article 16 TEU gives us the details. The Council is made up of a representative of each member state at ministerial level who is empowered to commit the government of that member state and cast its vote. So these are done sectorally, and this is set out in Article 16.6. So the Council meets in different configurations depending on the subject matter at issue. So if it's an economic or financial matter, then it's the Council of Economic and Financial Affairs, known as ECOFIN, which is the most powerful formation of the Council. If it's an environmental matter, then it's the Council on the Environment, and so on and so forth. Articles 16, 3 and 4 TEU explain that qualified majority voting in the Council is the norm. It's not the case that Council has to agree unanimously, which is normally the case in international law and international relations. A qualified majority is enough. And the blocking minority must be at least 4 Council members. So it's not possible for one member state to hold the EU hostage. Article 16.7 talks about the presidency of the TEU, and for this you also need to look at Article 236 of the Treaty on the Functioning of the European Union. Article 236 on the Treaty of the Functioning of the European Union talks about the Council adopting a decision on the presidency Council configurations. And that was done in Decision 2009-937 on the Council's Rules of Procedure. And the way that this works is that the presidency of the Council works in groups of 3 member states which hold the presidency for 18 months in all, so each member state for 6 months only. The Council presidency has considerable power in practice because with a large European Union, 27 member states, there is a huge need for coordination and making sure that the complexities of interests don't mean that the whole system just falls apart. And that configuration means that, as Martin Westlake and David Galloway have it, the presidency, although it's neither a formal institution nor a body, has become vital to the good working of the Council. As Craig and de Burke explain, the Council has significant powers in reality. Some of these are listed on the slide. The Council can, in fact, approve Commission proposals to become law. The Commission doesn't put forward a proposal in practice unless it knows that it's got enough or thinks that it's got enough support in Council for it. The Council can actually be proactive under the powers in Article 241 TFEU. It can delegate powers to the European Commission. It can control interinstitutional collaboration. We'll talk about that a little bit more in a minute. It has a major role in the budget. It has, as I said, external power to conclude agreements with non-EU states and significant powers in the European Union's common foreign and security policy. In terms of lawmaking powers, we need to look again at Article 291 of the Treaty on the Functioning of the European Union, which sets out the ordinary legislative procedure, and it talks about the 3 types of EU law that the institutions can make: regulations, directives and decisions. And these are defined in Article 288 TFEU. Regulations have general application, they are binding and they are directly applicable. Directives are binding as to result, and decisions are binding on those to whom they are addressed. Directives, in fact, have become the type of law of choice, and they have over time become more and more binding in precision as opposed to just result. There are some examples and a further explanation in this short YouTube video which discusses the roaming regulation and the data protection directive, and the hyperlink is there in the slide. Finally, just to touch on the European Council, not to be confused with the Council, Article 15.2 TEU explains that the European Council is the heads of state or government of the member states of the EU, plus the Council President and the Commission President. And what the European Council does under Article 15.1 TEU is sets the general political direction of the Union. And it meets every 6 months in what are usually called summits to do that. Under Article 15.5, the President of the European Council is elected by the Council for a period of 2.5 years, renewable once. So this is not the same as the Council presidency. This is the European Council President. Just to touch on interinstitutional agreements, with all of this in practice, what happens is that the main institutions have reached various agreements between them in terms of how they will exercise their powers. And this is encapsulated in Article 295 TFEU, which gives the institutions power to do that and to bind themselves without the say-so of the governments of the member states. Just finally, touching briefly on the position from the point of view of the UK, the institutional structures that I've discussed here, of course, do not apply to the UK because the UK has left the EU, but the agreement on the withdrawal of the UK, the withdrawal agreement, does make for institutional arrangements. It sets up a joint committee of the EU and the UK to oversee its application, and that is set out in Article 164 of the withdrawal agreement. And under Article 165 of the withdrawal agreement, that joint committee may delegate its powers to more specialised committees. So that's to do with the withdrawal agreement. Longer term, we don't know. It will depend on the outcome of the negotiations on the future trade relationships between the UK and the EU. There is bound to be some kind of institutional structure. All of the EU's trade relationships have some kind of institutional structures embedded and embodied in the legal instruments that set out those trade relationships. So I hope that was helpful, a very quick canter through a lot of detail which you will need to support your answers and your work in your workshops and the eventual assessment for the module. And just to keep it real, here is my daughter for a final word.
Hi gang, hope you had a good lecture and took good notes. Education's important.